They point out that appropriation statutes tend to be worded fairly broadly. They very rarely expressly direct the president to say, you must spend this, you shall spend money on this. They say things like the president may spend money for this, or they just simply appropriate monies for a purpose without giving any specific direction. And they say, essentially, without that sort of specific direction, there is no mandate that's binding on the president in this case. It's the Lawfare podcast. I'm Senior Editor Scott R. Anderson, joined by Lawfare Senior Editor and Brookings Institution Senior Fellow Molly Reynolds.
That's pretty clear to me. Congress did not mean for the procedures that it prescribes in the Impoundment Control Act, including the ones around litigation, if the executive branch is determined to be doing something unlawful. It did not imagine that it was the only arbiter of this question.
Today, we are talking about the rescissions request the president has put forward to Congress and what it means for the litigation over his cuts to foreign assistance. So, Molly, we have gathered here today for one of our, I think, signature at this point, because I think we are the only two people who regularly do them, conversational podcasts, digging into something of mutual interest and wonkiness, to talk about rescissions. This is big news. It's a topic I'm not sure either of us thought was going to be big news in our professional lifetimes, but it is very big news. In a way, it's probably one of the top 3 constitutional issues this administration is teeing up, which is not a small thing for this administration and the universe of constitutional issues it is teeing up. And has huge ramifications for government, for federal spending, for the whole menu of policy items Congress and the executive branch have traditionally weighed in on across all sorts of issue sets. Before we get into the specific context in which we're seeing this fought out, at least now, at least preliminarily, as this kind of first battle in the broader war over rescissions and the related concept of impoundment, and that's in the context of foreign assistance, talk to us a little bit about what it is a rescission is and how it relates to the concept of impoundments and the constitutional, and perhaps more importantly, in a way, at least immediately, the statutory framework that Congress has set up around them.
Yeah, so I'll just say to start off that I've spent most of my career thinking about the Congressional Budget and Impoundment Control Act, but almost all of it was about the budget half of that, and none of it was about the impoundment control half of it. And now here we are. But I do actually think it's important to remember a little bit of the history here. So when Congress passed the Congressional Budget Act in 1974, one of the impetuses, one of the things that sort of compelled it to act, was the fact that the Nixon administration had been pretty aggressively impounding funds, pretty aggressively disregarding decisions in the appropriations context that had been made by the Congress. And so one of the things that Congress did is it sort of stepped in and said, no, impoundments have always been illegal. Congress holds the power of the purse. We have these historical examples. We're not going to come in and say that the president is all of a sudden allowed to impound funds. What we are going to do is say that if Congress has acted in the appropriation space and the executive branch wants to do something that is at odds with what Congress has said, here are the options available for the president. So it's not like impoundments became illegal as a result of the Impoundment Control Act. The Impoundment Control Act prescribes how the executive branch is supposed to approach trying to sort of change what Congress has done in the appropriation space. And it prescribes a couple different concepts here. The first is this idea of rescissions, and that's, I think, a lot of what we're going to talk about today. And a rescission is when the president proposes canceling the availability of budget authority. So Congress has passed an Appropriations Act, so X amount of money should be spent on Y purpose. The president then proposes in the form of what we call a special message, which is a great term of art here, proposes that no, the executive branch actually thinks we shouldn't do these things that Congress has just appropriated funds for. And then Congress has the opportunity to adopt a resolution affirming those rescissions. We can talk about sort of the procedural aspects of that. But basically, the rescissions piece, so the idea that the executive branch would propose a cancellation of budget authority, Congress has to act under the law to affirm those rescissions. And if Congress doesn't do so, then the executive branch is not supposed to rescind the money. It's not supposed to cancel the spending. So that's the idea of rescissions, or sort of canceling money entirely. The second thing that is prescribed in the law is the idea of deferral. And there, the notion is that the president can propose delaying as opposed to canceling budget authority. In the original Congressional Budget and Impoundment Control Act, one house of Congress could then step in and end the deferral, so sort of cancel the delay that the executive branch had notified Congress that it wanted to do by adopting a resolution that disapproved of the deferral. And then in the early 80s, in a Supreme Court case that, bedevils me to this day, INS v. Chadha, the Supreme Court ruled that this kind of one-house legislative veto was unconstitutional. And then in a follow-on D.C. Circuit case, the D.C. Circuit ruled that the deferral power, so this idea that the president could defer funds, was unseverable from the one-house veto. So then Congress had to step in, revise the law, said that deferrals were okay, but only for specified reasons. We can get into this later too. That don't include policy disagreements, and that a deferral could not extend past the end of the fiscal year in which the president was proposing the deferral of funds. And then the last concept I think is helpful to kind of put on the table to start is this notion of programmatic delay, which is essentially like an extra statutory concept here. Programmatic delay is the idea that if an agency is facing what GAO calls operational factors that unavoidably impede the obligation of budget authority, that it's okay for the agency to pause spending. And basically what we have here is Russ Vought, the head of OMB, is claiming that much of what we're seeing right now actually falls under this idea of programmatic delay. And I think a lot of folks, including our friend Eloise Pasikoff, who's been on the podcast before, have basically concluded that the concept of programmatic delay has expanded so far to sort of eat the definition of deferral. And now we have this world where agencies are regularly doing what actually should be deferrals, which they have to notify Congress about, but they're just calling them programmatic delay. And then Congress doesn't know that they're happening unless they find out in some other way because the administration doesn't have to report on them. So that's kind of where we are. That conceptually, that's what's at stake here. I think we're going to talk most specifically about this idea of rescissions, but we'll touch on these other concepts too. So to sort of pick up there, Scott, at the beginning of June, the administration sent a special message with proposed rescissions over to the Hill. I think it's about $9.5 billion.
That's my recollection. I actually forget the top line because I haven't added all the lines together.
Yeah. Don't hold us. Neither of us do math for a living. One of us is a lawyer. One of us is a political scientist. Don't hold us to that, listeners. But what is in there? What are the things that the administration has actually told Congress under the terms of the Impoundment Control Act that it wants Congress to rescind?
So this appears to be, a first salvo. In theory, we may see additional special messages for other funding and spending that we know is getting held up across the board on all sorts of issues. But this is kind of taking aim at two fairly convenient targets, I suspect, particularly for Republican allies of the administration in Congress. One is the Corporation for Public Broadcasting, which is basically having its future funds for 26 and 27 completely wiped out if this rescission were actually enacted. Rescinding it entirely, so that means PBS, NPR, other entities that benefit from that would essentially receive no funding, at least under the funds that have already been appropriated and were already on the table for it. And then there is a whole set of individual rescissions regarding foreign assistance. Foreign assistance isn't one big category. It is a ton of individual accounts and programs that are, I think, best thought of as a constellation of different, often interrelated, sometimes kind of overlapping in purpose, sometimes fairly independent accounts with different statutory authorities that tied to them. But across the board, it sees like a pretty dramatic cuts in foreign assistance. Just to run through a couple of the items that we see in this list, we see a substantial cut of international disaster assistance funds for 2025, about an eighth of the remaining funds. Huge chunks of fundings for the Inter-American Fund, the African Development Bank, and U.S. Institute for Peace. Remember, these are three of the programs the Trump administration tried to take over. In at least two of those cases, they've essentially been stopped from doing so, at least temporarily, as litigation is ongoing, although in the case of USIP, that happened after several weeks. So there's some pretty terrible stories about the headquarters having been having had letters of the sign torn down for some reason, while it was left unattended or in the hands of folks from the White House. But substantial cuts to their programming, even though those institutions are now more or less up and running, at least for the time being. Huge cuts from international operations accounts. Those are the accounts that provide funding to the UN or for various UN programs. They specifically say it's related to cuts to UNRWA, cuts to a lot of UN programs the administration has indicated to backing out from. But perhaps the most notable items, I would say, is that you see a huge cut in funding to AIDS-related public health spending. That, of course, has been a huge kind of flashpoint, including with Republicans in Congress, because PEPFAR spending and other related spending on AIDS issues actually has a fair amount of bipartisan support historically. So that $400 million in funding that they're trying to cut from that is likely, I think, to be one of the more higher profile items, because we're going to hear more about pushback from that, at least we have so far. But the really dramatic stuff is to the economic support funds, the development assistance funds, and migration refugee assistance funds. Those are often referred to as the DA, ESF, and MRA funds. These are three of the big traditional big buckets of foreign assistance funds. And you are seeing ESF and DA funds cut by as much as, in the case of ESF funds, more than 50%, or pardon me, of DA funds, more than 50% of their appropriated funds. So we're seeing dramatic cuts in spending across, again, the premier major foreign assistance funds. ESF funds, DA funds are used to fund most of what you think of as foreign assistance, essentially. And then migration and refugee assistance funds are being cut by 25%. But there's also a note in there about other funds being reallocated for other purposes, or hinting at least reallocation for other purposes and shifting in focus towards things like removal and repatriation. So it is really, really indicative of the broad policy swing the administration has already tried to implement through the agency. This is the legislative and funding backup for that, basically trying to get Congress to bless and sign off on the policy decisions the administration has already started moving towards at the agency level. But Molly, the real question I think everybody has is, where is this going? So tell us where this bill actually is and where we think it's going to go, both procedurally, where we know it's going to go, and what the odds are of it getting there, I guess, to the extent we know.
Yeah, so it cleared the House by a vote of 214 to 212, so very narrow margin. It was another one of those situations where, Speaker of the House, Mike Johnson, it wasn't clear if he had the votes, and they went to the floor anyway, and there was arm twisting, and there was some literal shouting on the floor, but they did get it over the finish line in sort of the full form that had come over from the White House. It's a little unclear sort of what flipped people in the end, whether this is one of many situations where there are some House members who believe that the Senate will change the proposal when it gets over to the Senate, and then it will come back to the House, and the ultimate version might be more to their liking. The risk there is obviously, like, if the Senate doesn't change it, then you have already voted for a thing that maybe you don't like a lot. But so it does go over to the Senate next. We're recording this on June 16th. It's a little unclear exactly when the Senate is likely to take it up. There's a 45-day clock. It's a little different than like some other kind of clocks that we talk about in the congressional procedure world. Often we are talking about this kind of deadline. It's because the expedited procedures that are available for considering these bills without the threat of a filibuster in the Senate are only available for some period of time. That's not what's happening here. Here, it's that after that the president has sent the special message proposing the rescission. And if Congress doesn't act in 45 days, then the administration is supposed to spend the money that it has proposed for rescission. So it can pause the spending while Congress works its will in the rescissions process. But the 45-day clock, which I think is supposed to run out on July 18th, if it elapses with no congressional action, then the administration is supposed to spend the money. Separate question as to what this administration, what this White House would do if it got to July 18th and Congress hadn't acted. Would they sort of take that as a message, special or otherwise, that they are in fact supposed to actually spend this money? I think there's probably an argument that if we actually went through all of the steps that are prescribed in the Budget Act for the rescissions process and got to the end and there was no rescissions bill, the courts might look differently on the executive branch's actions after that point. We can talk more about that if you want. What I will say is that there are, when it gets over to the Senate, there are some questions about how the Senate can amend the proposal. I think it's pretty clear that they could, if they wanted to, narrow what the House has passed. That would obviously then need to go back to the House for its approval. So let's say, for example, there weren't the votes in the Senate for the rescission of the PEPFAR funds, because, Scott, as you've pointed out, that historically has a lot of bipartisan support. Or there aren't the votes in the Senate for the rescission of the funds for the Corporation for Public Broadcasting. I think the Senate could amend the proposal to remove those and then send it back over to the House. It's a little less clear, to me at least, what the Senate can do in terms of adding things if it wanted to. I will say that in the 51 years, since the Congressional Budget and Impoundment Control Act was passed, we actually haven't done this that many times. And the President and Congress haven't used this procedure that often, in part because if you sort of think about what it is doing, like Congress has said, we want to spend this money. The president has signed a law saying we're going to spend this money. And like, yes, we do appropriations legislating these giant packages. And so you can, I guess, imagine the idea that, some things made it through the process that enough people don't like that you could undo them. But one of the reasons we do appropriations in big giant packages is because it's an opportunity for log rolling. Everyone gets something that they want. But what you end up doing in the rescissions context is you identify specific things that have, say, specific constituencies that might be mad about them if you take away the funding, and then you ask members of Congress to sort of face those politics instead. So I don't know what's going to happen, but that is sort of the next procedural step in the rescissions process.
And to be clear, in the Senate side, just to be express about this, I think you already touched on it, but I want to be clear for listeners. It's a 50% threshold in the Senate.
Yeah,
it's not a filibusterable, subject to the filibuster.
You're right that I should be even more clear about this. So yes, if the Senate takes up a rescissions package, it has a statutory limit on debate on the legislation, which has the effect of preventing a filibuster. And so yes, if the Republicans could find 50 of their own votes plus J.D. Vance available to break a tie, they could get this through on a party line vote. And so then the question is really, are there 50 votes within the Republican conference for exactly what the House has passed, for something that looks different than what the House has passed, and we will have to see. So that's sort of rescissions in the active legislative process right now. But Scott, another place where we've seen this concept come up is in some of the litigation over the administration's actions to pause, in this case, foreign assistance funds. Can you sort of just walk listeners through the case where the government has started building an argument that relies on in part on the existence of the rescissions process, and then we can kind of talk about what that tells us about how the government is thinking about these issues and kind of what we make of the government's argument.
Yeah, it's really, really interesting. This was, to give listeners a peek behind the curtain, the impetus for Molly and I doing this podcast, because in a conversation, we realized we'd both been following separate tracks of this issue set, her on the legislative side, me on the litigation side, and suddenly they intersected. And we thought it was worth tying those together. We haven't seen a lot of people kind of connecting the dots on this who have been following this. The case in question is under the caption AIDS Vaccine Advocacy Coalition via U.S. Department of State. It's consolidated with another case called Global Relief Coalition via, I believe, U.S. Department of State, but it tends to get the AVAC caption as the lead one. And this is a challenge brought by a really kind of pretty diverse array of grantees of foreign assistance funds, primarily USAID, some Department of State, that are either implementing agencies or the end recipients of foreign assistance funds that were interrupted by the Trump administration's policies they implemented pretty early on, suspending initially almost all foreign assistance, and then quickly implementing a whole wave of cuts. This was the first case that went to the Supreme Court on the emergency docket since after President Trump entered the White House, which has become a fairly common occurrence, where actually the district court's preliminary injunction, or TRO, I should say, in favor of the plaintiffs was upheld by the court. And so it has been kind of the tip of the spear in a lot of these debates over these impoundments arguments, because foreign assistance was the one kind of hit first and hardest by the administration. and now is the one that's being put forward for rescission. It's not a coincidence. I think they feel better about their ability to rally their caucus around cutting foreign assistance than they do maybe a lot of the other budget cuts they're considering. So it's a convenient political space in which for them to have these arguments. It's also one where they have, as we're going to see in a second, walking through the litigation, the added valence of a foreign affairs power, an area where the president traditionally exercises a lot more discretion, or at least claims a lot more authority in a domain. And so it has that kind of added level of argument. So in this case, we essentially have had a preliminary injunction in place that has said, government, you need to pay out all the people that were supposed to get funds for work they had already completed prior to a date in March. I can't remember exactly which date off the top of my head. Then there's all this question about all these funds moving forward that you had agreed to provide people that you have since suspended or canceled. The court said, each of those we're going to have to look at on an individual basis. So people are going to have to file those separately, either as separate matters or as an amended complaint, because we need to dig into the nitty gritty of the exact details of those cancellations to understand whether they're legal or not. But on the third front, the government does have to spend this money. And so he has said to the government, you need to have a plan for how you're going to spend this money that Congress has appropriated, because if you get to the end of the period at which where you get close to where the money is going to expire, because most funds are appropriated for a fixed period, particularly foreign assistance funds, and you haven't spent the money, you will have committed an unlawful impoundment. And that's going to be a problem on a couple of different fronts, and it's including that it violates Congress's constitutional authority. The court has asked for this sort of plan about exactly how the administration intends to spend this funding. They haven't got anything about it, something we'll circle back to in a little bit. Instead, what they got on June 3rd is a really, really substantial big brief that lays out, I think, in the greatest detail we've seen so far across all the different litigation on this, although perhaps I've missed something, that what appears to be the legal arguments they are going to lean on to argue the president can cancel these funds. And it boils down to kind of three chunks. And before I get into this, I should note this brief, because of a weird procedural thing, is actually going to have to be broken up, redrafted, and refiled because they went dozens of pages over the usual page limit. And they argued that's because consolidated matters. They thought they could just add them together and do one brief that's twice as long. The court said, no, I'm afraid that's wrong, and is making them refile it in either a slightly shorter format or as two separate briefs in the two different matters. We'll see what ends up happening. But presumably it's going to look a lot like this, even though this particular brief is not going to be the one that's argued. And that revised brief, I believe, is due next week. So we'll see if there may be additional arguments there. But at least in this brief, they basically put forward kind of three related arguments as to why the Impoundment Control Act and the Constitution don't allow the Trump administration to do what it's doing in kind of canceling these funds. I should note they also make a jurisdictional argument. We've seen in all these cases that the Tucker Act says that all these disputes should be taken to the Court of Claims and then to the Federal Circuit, as opposed to being dealt with in individual district courts. That issue is currently being briefed and argued before the en banc DC Circuit in a separate matter, the Voice of America case, Widu Kuswara v. Lake. Doesn't look good for the government on that argument. The en banc DC Circuit in preliminary rulings has not been very friendly to it, so I don't think they're going to win on it. But we'll see. So this all may get mooted out if that ends up being the case. We'll have to get re-argued before the Court of Federal Claims and then the Federal Circuit. But at least on the substance, once you get past that jurisdictional argument, they say basically three things. First, they argue that the Impoundment Control Act creates what they call a reticulated, which I don't think is the proper use of that phrase, which means net-like or web-like. It's not clear how that really applies here, but a reticulated system for structuring interbranch debate over spending decisions that they essentially argue is supposed to be exclusive. So under the Administrative Procedure Act, the cause of action that the plaintiffs are relying on in this case, APA says you can't pursue claims under the APA if Congress has specifically foreclosed your ability to pursue those claims. And they are saying that's what they did here with the Impoundment Control Act. They point to the specific fact that they have this kind of interbranch dialogue process that they say the Impoundment Control Act is supposed to facilitate. They point out the Impoundment Control Act allows lawsuits by the Comptroller General, which they say kind of renders suits by private individuals redundant and unnecessary. And they point to language located at Title II of the U.S. Code, Section 681, which says that the act should not be construed as affecting in any way the claims or defense of any party to litigation concerning any impoundment, as suggesting no private claim was supposed to be advanced by the enactment of the law. Although I would say, I think the most natural reading of that provision might well be the opposite, that it wasn't actually intended to preempt any existing sort of claim. Regardless, they essentially argue, A, that the Impoundment Control Act, is this reticulated system of interbranch relations, is supposed to be exclusive and doesn't allow for private parties to pursue lawsuits under the APA or other causes of action. If they were to lose on that, they then go on and argue, oh, by the way, there isn't any statutory basis for actually compelling us. The APA only allows plaintiffs to compel the government to take action unlawfully withheld. In this case, that's not what's happening. They point out that appropriation statutes tend to be worded fairly broadly. They very rarely expressly direct the president to say, you must spend this, you shall spend money on this. They say things like the president may spend money for this, or they just simply appropriate monies for a purpose without giving any specific direction. And they say, essentially, without that sort of specific direction, there is no mandate that's binding on the president in this case. And then they point out that the Impoundment Control Act, which does essentially say, hey, you are supposed to spend this money, only really does so after a failed rescission request. And this is where this June 3rd rescission request comes in, because they say, hey, we just filed this request. We're within our 45 days. It's still pending. So there's no obligation on us right now to go forward and spend this money. That only kicks in after a rescission is rejected after the 45 days, at least at the earliest. So the Impoundment Control Act doesn't independently provide any basis for saying, oh, these funds are being unlawfully withheld either, in addition to the appropriations legislation itself. They also mentioned the Anti-Deficiency Act is not providing an alternative basis for this on the logic that it has a separate sort of enforcement scheme. That's another law that gets kind of pulled into the ecosystem here that bars kind of inappropriate federal spending, that they argue doesn't really go in here. And then they argue that judicially enforcing the Impoundment Control Act at this stage in the way the plaintiffs are asking would essentially deprive the president of discretion that the Impoundment Control Act was intended to provide. And they point out that there are a lot of contingencies where the president is supposed to be able to delay and hold funds, at least in their reading of law and practice in the space. They specifically here nod at what we're going to talk about a little bit later, the pocket veto scenario, where if a rescission request is submitted within 45 days of expiration, under their reading of the law, and a reading that they say the GAO had several years ago but has since reversed itself on, they essentially say that means that money goes away unless Congress takes affirmative action to preserve it, which would be a backdoor way of getting rid of these funds potentially if you were to buy that interpretation of the law. And then their third argument is, in reading all these statutes, essentially, the courts have to be super, super careful not to intrude on the president's broad, extraordinary power over foreign affairs. And they specifically say, hey, look, the president is supposed to have lots of discretion. Congress gives it lots of discretion. That's because it has to, because the president controls foreign affairs and has to have that leeway in interpreting and applying these statutes. And by the way, they point out that at least as a constitutional matter in their view, there is actually no presumption that the executive branch must expend all the funds that Congress appropriates. They say there's lots of cases earlier in American history where the executive branch did not spend all the money appropriated by Congress, and that is discretion provided to the president. Maybe the Impoundment Control Act changed that, but there shouldn't be an assumption against that, particularly in a space as sensitive as foreign affairs, where the president usually has a lot of discretion for good constitutional reason. So those are the three big bucket arguments. I want to know what you think about these, Molly, because they're pretty extraordinary. As I frame them, I tried to frame them in a colorable light, and a light that puts them in the kind of best face forward, as I think the briefing tries to. But on reading this, they struck me as actually pretty extraordinary. And I want to see if you agree with me. Let's start with the first one, this idea that the Impoundment Control Act is supposed to create this exclusive system of remedies that shuts down private plaintiffs pursuing these sorts of claims. What do you make of that?
To me, it is pretty clear that that is not what Congress intended when it wrote the law. I think it's that basic. And so you can go back, as I enjoy doing, to the actual legislative history of the development and debates around the Impoundment Control Act. And during debate over the Impoundment Control Act in 1974, Sam Ervin, who was one of the lead managers for the bill in the Senate, when discussing the power of, so the sort of way the legal remedies happen on behalf of the legislative branch in the act, is that the Comptroller General, who's the head of GAO, is empowered to sue in situations where GAO has determined that there is an illegal impoundment, whether that's funds that the administration is rescinding without having gone through the process of proposing the rescission and having Congress act, or if the administration is using the deferral power in an unlawful way. And in the debate over, I'm going to read this, in the debate over the bill, Ervin said, the Comptroller General will be granted authority to sue in the federal district court for the District of Columbia to enforce the provisions of the title. So these, what I was just talking about, using attorneys of his own choosing, 25 days after he gives notice to Congress. The idea there was that, if GAO makes a determination and Congress does actually want to use some of its legislative power to respond to that, it should be given the opportunity to do so. And then he says, this authority is not intended to infringe upon the right of any other party to initiate litigation. That's pretty clear to me. Congress did not mean for the procedures that it prescribes in the Impoundment Control Act, including the ones around litigation, if the executive branch is determined to be doing something unlawful. It did not imagine that it was the only arbiter of this question. And so that, in some way, it couldn't be clearer to me that the government here is arguing, in pretty clear contravention of what Congress meant when it wrote the law in the first place.
And I'll say, just to foot stomp that, I have the exact same reading, and that's the part that jumped out at me. And particularly this quote of this 2 USC 621 language is really 681 language, is really extraordinary, because you could, before the Impoundment Control Act, sue over an unlawful impoundment, at least if under the APA.
There are dozens of those cases from the Nixon administration.
And it says very clearly, the statute's not supposed to affect the way those claims or defenses can be brought. So how can you then argue that it's supposed to preempt them? It's just really, really bizarre in my mind, and an incredibly, I would say aggressive, but just kind of, it's not quite artful enough to be aggressive. I don't really know what to make of it. It is really just a very optimistic reading of the law and the statutory text on behalf of the government in a way that I think is unlikely to carry water. But we will have to wait and see to know for sure.
So there's also this question that when you were sort of really helpfully running through the arguments that the government makes, there's this question around the notion that there's no mandatory action appropriate for APA relief here. What do you make of that piece of the argument?
So I do think, particularly when you talk about the appropriation statutes, I want to turn it back to you for the Impoundment Control Act itself. But in terms of the appropriation statutes, I actually think this is probably the government's strongest argument. And it's where we've seen this judge in this litigation actually refused. It's the area where it's refused to go so far at the plaintiff's urging. When the plaintiffs were saying, hey, look, we have all these grants and contracts that were in place. The administration has suspended. You should restore them because there is no universe in which they can meet their appropriations obligations and avoid an unlawful impoundment, except to give us the money this late in the game. The court said, look, we have to look at the individual authorities here. These statutes are really different. I mean, this is, again, a super broad, diverse coalition of different plaintiffs with different positions, different buckets of funds from different funds and authorities and programs and contract, not to mention individual contracts and grant agreements. So the legal nexus of issues is really different across cases. And in this case, this judge, at least, was not willing to go so far to say, I can resolve this sort of writ large. Now, the government really, really minimizes the likelihood that any of this language is likely to be interpreted or should be interpreted as obligatory or binding. And it says a very high bar for that. It says essentially only if it says money shall be used for this purpose should that be it. I don't think that's right in terms of congressional intent, and I kind of doubt at least the district court and the DC Circuit are likely to read the law as so demanding in terms of what is obligatory. Maybe the Supreme Court as well. I'm a little less confident there because, Congress has been legislating against this backdrop of the Impoundment Control Act for the last 50 years. And they know there are obligations to spend this money. And then so particularly where they say this money is appropriated for this purpose, I think it's hard to get around the understanding that they thought that money was supposed to be spent for that purpose within the statutory window that they're providing, right? Or else why would you provide a statutory window at all for expiring the funds? I do think, however, that there are a number of cases in a lot of these statutes where there is a suggestion of permission or of discretion, where the president may use things for certain purposes. And there you are going to find courts and potentially this judge say, I'm not quite ready to say this is strictly obligatory. But it's going to be very, very case specific and context specific and statute specific. And that's a much more complicated terrain to have this fight down. You kind of need the resolution at the categorical legal issue level before you can get down into that sort of nitty gritty. But eventually I kind of do suspect we will get there for some of these. I don't know what that means for the vast majority of these plaintiffs. I think a lot of them will still have obligatory argument they can make that they are entitled to a chunk of these funds. But I haven't sat down to figure out how many fit under what type of authority or not, or what sort of structure. And it's worth noting, while there's a lot of plaintiffs in these cases, there's still a minority of the overall of affected parties that are still, at least in many of their views, entitled to foreign assistance funds. So it's hard to know exactly how this shakes out in terms of individual plaintiffs. And it's worth noting, I do think this statutory interpretation question is one area where the constitutional issue will come into play in the executive branch's favor in a little bit. We can talk about that in a minute. I think it's a little overblown, but statutory interpretation context, you might see it. A number of judges say, well, in cases where it's a little even split, where there's some ambiguity, we are going to defer to the president a little bit on this because there is clearly a foreign affairs nexus. Before we get to that, though, let's talk about the Impoundment Control Act. So they also make this argument that the Impoundment Control Act isn't supposed to give anybody this sorts of claim because the Comptroller General has this exclusive role, and that there's no obligation to spend this money until this 45-day window after the rescission request comes down. That's where the obligation kicks in. And then maybe there's a pocket rescission, so that doesn't even apply. What do you make of that, Molly?
To me, just really ignorant of how the U.S. Congress works. I don't, because basically, taken to its extreme, what that argument is saying is that every time Congress passes an appropriations bill and the president signs that appropriations bill into law, it is, just an idea of what could happen. But if the president chooses to sort of send a package or separate messages rescinding every single thing in the appropriations bill, then nothing has to happen for 45 days. And if you sort of take it even further and think, no, Congress would have to actually take up every one of those rescissions bills and vote them down for the underlying appropriations language to take effect. Like, what is it imagined that the U.S. Congress would do with any of its time other than reprocess all of the legislative decisions it has already made when it wrote the law in the first place? Like, I'm struggling with the words here because to me it's so ignorant of the institutional realities and the way the institutions function and are supposed to work together that it just strikes me as it's just a really illogical argument.
Well, and I really think the fact that they decided to go ahead and talk about pocket rescissions, this idea that if you file a rescission within 45 days of the expiration of funds, they just magically go away, is like a strategic error on their part, because they are basically just shining a bright light on the biggest logical gap in their whole structure, which is that there's an escape hatch at the end of this that is completely inconsistent with Congress's purpose, and at least the way that we're going to interpret apportionment and deferrals on these other authorities any administration could use at any time to get rid of any of these funds. And go ahead and previewing that, which is not implicated by this case, by the way, previewing that, I think raises alarm bells for the court in a way that otherwise maybe they could have been like, well, we're going to wait to the end of this process. We're not going to try and obligate it. And it's worth noting some of this stuff is probably going to get mooted out because we're not going to see even the newly filed briefs of this until a week from now. Who knows how quickly the court's going to move on this, but the rescissions package 45 days is going to be up in mid-July. I suspect it's going to be a lot more convenient for the court in this case, given that all the funding here is implicated in this rescissions package, to kind of wait it out and then decide. So we may not ultimately get a resolution on this point because the 45 days will be ripe in this particular case, but it's a tricky argument. And I think maybe they were a little too ambitious in having excitedly settled on this legal argument and including it in a way that may not actually help them persuade the judge, but we'll have to wait and see.
One more thing on your historical argument that you made before. I just want to plug for listeners that our friends at Protect Democracy have a truly masterful report on the sort of historical myth of the presidential impoundment power. We'll put a link to it in show notes. They've also filed an amicus brief in this case that we're talking about in AVAC that relies on a lot of and tries to rebut some of these arguments that there was a time before the Impoundment Control Act when all of this was okay. And so, again, going back to this notion of this has never been a thing that the president really had the power to do.
And it is the fact that the argument that he did, in case you're wondering, is a very much a pet theory of the general counsel of the Office of Management and Budget, Mark Paletta. He wrote, or co-authored, I should say, a number of pieces about this. The one I'm most familiar with is a piece from the Center for Renewing America from last summer. It's called The History of Impoundments Before the Impoundment Control Act of 1974. That is, if you read this brief, that's what the argument, the 2 paragraphs that they make comes from.
The other CRA, as I refer to it, because
yes, exactly. Exactly. But it is, Protect Democracy did do yeoman's work kind of rebutting this point for point. And it is a very favorable reading of history, to say the least, at least from my assessment.
Before we go on to talking about sort of what comes next in all of this, beyond just this lawsuit, I also want to ask you, Scott, as someone who thinks a lot about the foreign affairs powers of the presidency, what do you make of the arguments in this brief that are in that context?
Yeah, so this is a recurring theme we've seen in this litigation since the very beginning. I wrote a piece on it like 2 or 3 months ago for Lawfare, pretty early on, kind of trying to rebut this idea that foreign assistance is somehow an Article 2 presidential authority. It just has never been viewed that way. I mean, foreign assistance has always been categorized by the Supreme Court and by the executive branch most of the time as an expression of the tax and spend power of Congress under Article 1. So it's never been something where the fact that it touches on foreign affairs somehow makes it the president's authority. And the president doesn't have any inherent authority to provide funds and provide them to other countries. He can only do that pursuant to delegated statutory authority. So, the normal constitutional order would be the president actually needs some sort of principle on which he can exercise that delegated power. Like Congress actually can't hand that power over to the president, even if it wanted to. And here it's far from clear that it has. In fact, I think it's fairly clear it hasn't entirely. In foreign affairs context, there is an accepted principle that the non-delegation principle that normally limits that delegation is much weaker, doesn't apply to the same extent as it does in the domestic context. I suspect that does kind of bleed across into the foreign assistance context, at least for most judges. The Supreme Court in particular, a number of the justices, well, they may take issues with other ways the administration is approaching this, I think are likely to view favorably the idea that in foreign affairs context, generally, the president should get the benefit of a doubt. Justice Kavanaugh has written a lot about this. Chief Justice Roberts' decisions tend to lean in that direction. Justice Amy Coney Barrett has leaned in that direction in state secrets privilege contexts and other contexts over her brief time on the court. I think that's all indicative of the fact that that argument is going to have a little bit of grab, but it is way overstated the way the government puts it forward. This idea that the president has a ton of authority about dictating this, that Congress can't intrude on, or that the Supreme Court or other courts can't interpret contrary to the president because that raises big constitutional questions. I just don't think that carries water. I don't think most courts are going to view it that way. I'm not surprised the executive branch makes that argument. It's not unusual for them to do it. And this idea that we're going to pull out big constitutional authorities and not rely on them as an independent basis for what we're doing, but to try and implicate them to push the court away from statutory interpretations we don't like because of the principle of constitutional avoidance, saying, hey, we don't even want to implicate this constitutional question, so you better just give us our way on the statute so we don't have to reach that. It's not an uncommon executive branch litigation tactic, and so I'm not super surprised to see it, but I don't think it carries water. And it is, while it might apply in a variety of other foreign affairs contexts, particularly in the foreign assistance context, it's just has never been viewed that way, including by the Supreme Court when it's looked at foreign assistance cases relatively recently in the past. Instead, it always sees it as a tax and spend sort of issue. And so I don't think it's going to carry the day, but maybe it helps a little bit on marginal cases on the statutory front. So, Molly, we've set up that there's this big brief and debate happening. There's a big debate happening in Congress. We're at kind of a holding pattern, at least for the moment. We're waiting to see what the Senate does on the rescissions package. We're waiting to see new briefing and argument. in the court decision before D.C. Federal District Court in the AVAC case. But we also know there's a lot of percolating happening on other fronts in Congress, in the administration, both in the litigation in terms of other sort of collateral actions that are happening. So let's run through these a little bit. First, why don't we talk about what we're hearing about Plan B and a couple of Plan Bs? Because this administration has not been shy about saying, here's what we're planning to do if this doesn't work, or what we are likely to do in other packages where we can't get Republicans on board with rescission. They hint at it in this brief, as I mentioned, in discussing pocket rescissions. So talk to us a little bit about what their plan seems to be if and when this doesn't work, or if it can't be extended to these other funding cuts they want to make.
Yeah, so we might call these their Plans B. There's sort of two parts to this that have been reported over the last week or so. One involves this idea of deferrals that I mentioned earlier, which again are the ability of the executive branch to tell Congress that it's going to pause some funding, but under the law, that pause can't last past the end of the fiscal year for which the funds are supposed to be obligated. And deferrals are allowed only for specific reasons. I'm going to read what those are because part of the administration's strategy here involves an argument about one of these things. So number one is to provide for contingencies. Number two, to achieve savings made possible by or through changes in requirements or greater efficiency of operations. Or three, as specifically provided by law. It's the first of these, this idea of providing for contingencies, that the administration reportedly is going to rely on to propose a set of deferrals. And here, the reporting suggests that OMB would submit to Congress some deferrals that are supposed to run out at the end of this fiscal year. And they are planning, again, according to this reporting, to use the fact that we are approaching the debt limit. We are approaching the deadline by which Congress must act to raise the nation's borrowing limit as the contingency that requires this kind of pause in federal funds. I'll say two things. One, the sort of magnitude of what we're talking about in terms of pausing funds, while like large and consequential for the people who rely on the funds that would be paused, like it pales in comparison to the size of the federal debt. So this really isn't a thing that's going to make a meaningful difference over any kind of real time horizon in our approaching the debt limit. Like it could matter, for a little bit of time, but not, it's not going to solve our debt limit problem. And secondly, I'll just say that this question is not new. One of my overarching principles for watching Congress is that there's virtually nothing new under the sun. In the 90s, the Clinton administration explored this idea of deferrals as a way to postpone the date by which they needed to act on the debt limit. There's an OLC memo that explores this that is, as you might expect OLC to be in this set of circumstances, somewhat favorable to the idea that the administration could do this under the argument with the justification that the debt limit is the reason. So that's sort of one thing that might be coming. A second thing is this idea of pocket rescissions that Scott was talking about before. And so the idea that if the president submits a rescission request that's close to the end of the fiscal year, and then you get to the point where the 45-day clock, where the end of the fiscal year happens before that 45 days runs out, you sort of like the backdoor way to effectuate the rescission without Congress having to act. The Trump administration tried this in its first go round. And in 2018, GAO said that this was not allowed, that basically the law requires the executive to propose these things in a way that would ensure the prudent obligation of funds in a timely fashion. And so that, you can't be too cute by half, basically. But at the time, and again now, Russ Vought has signaled that he believes different. And so I think we should expect the White House to try that again as well. So that's a little bit of like one line that has been reported on. Scott, in a separate court case, we also have some signs of ways that the administration might be, again, wanting to sort of play around with deadlines and the idea of no year money and all that kind of stuff. You want to talk a little bit about what's happening with the National Endowment for Democracy?
Yeah, this is the case. National Endowment for Democracy of the United States of America, that's been ongoing, was early on one of these kind of second stage foreign assistance cases. But the NED is in kind of a very unique position in that it has a much more express and direct statutory directive indicating funds will be directed towards it. And so it's one where early on, the administration initially resisted spending, but then pretty quickly caved once litigation was initiated, probably because they talked to the Justice Department and realized they were not going to win that one. But in this case, they've done something a little bit interesting, which is, of course, we have had in the last few months a continuing resolution providing additional funding and kind of re-upping the existing funds available for a variety of purposes, including the National Endowment for Democracy. And in a status report last week, we saw the administration indicate over objections from the plaintiffs that essentially they read the continuing resolution as allowing them to hold funds much longer than they would otherwise. It's essentially broadening the window until the end of the continuing resolution, not towards the prior resolutions, which various funds that have not yet been paid out were held towards. So they are now saying they're going to hold a bunch of funds appropriated for the National Endowment for Democracy in 2025 for their use in 2025 until 2026, which is when the continuing resolution runs towards. This poses all sorts of operational questions for the National Endowment for Democracy. Obviously, this could have much broader ramifications because if you buy that this is something the administration can do in this context, where again, there's much more express language and much more established practice of this money being given pretty much as a lump sum to the National Endowment for Democracy, once it's appropriated. If you buy this sort of argument, you could see it applied a lot more broadly to, if nothing else, kick the can down the road. And that's kind of what this administration wants to do. They want to withhold this funding in the interim. Everything they've been doing so far is kicking the can down the road because a lot of these are arguments that probably aren't going to bear out ultimately in the courts if they get there. But maybe they don't have to get there. And if they can win in the short term and drag out enough, they'll eventually win in the long term, particularly in the foreign assistance context where you're going to see a lot of foreign assistance partners fold and collapse or declare bankruptcy and therefore not be available. And some have argued that's actually part of what the administration is trying to accomplish here. So if that's the case, this is a strategy that could be dangerous if it actually carries through. Now, this is just in a joint status report. It is, not a litigation position. It's not something that necessarily has always been clear. It's been fully vetted through the Justice Department and through other officials that would have to weigh in on whether this argument actually carries water or not. They are certainly going to get strong pushback from the National Endowment for Democracy. I strongly suspect they're going to get strong pushback from the court as well. But we'll have to wait and see. And this may be another front where we're going to see the administration just essentially try and push this whole set of arguments one more year further back and maybe all the way to 2029 if they can. But Molly, this isn't the only front we've seen action on from the administration, from the courts. We've also seen GAO itself be really active. Just this morning, we woke up to a report that they had issued a second finding indicating that the administration had engaged in unlawful impoundment in withholding funds related to certain library programs. At the same time, we also know they've issued a couple other decisions where they found certain funding withholdings haven't amounted to impoundments. So talk to us about what the GAO is doing in this space, how it's parsing these different kind of efforts to hold up funds on the part of the administration, and the role that's likely to play in this broader debate.
Yeah, so we know from testimony given by the Comptroller General in front of Congress within the past couple of months that GAO has at least 36 open investigations into actions by the executive branch to determine whether those things constitute illegal impoundments. And we got 2 decisions in that context today. One involving wind energy programs at the Department of Energy, where GAO held that that was not actually an illegal impoundment. And the second involving funding for the Institute for Museum and Library Sciences, I believe is IMLS, that it does constitute an illegal impoundment. And I think this sort of illustrates a couple of notable things. One is it reminds us again that under the Impoundment Control Act, this is a responsibility of GAO. This is a job that GAO is empowered to do, to investigate whether something constitutes an illegal impoundment, whether it constitutes a cancellation of funds that the executive branch did not seek a formal rescission of, or whether it constitutes a deferral usually for reasons that are not one of the ones that are prescribed in the Act for why the administration could defer the funds. And so one possibility here is that this gets followed up with litigation. GAO has not historically actually litigated these cases, which is usually because the executive branch just unfreezes the money, like does what it's supposed to do. I'm not super optimistic that this administration is going to sort of take a GAO finding and say, you know what, we were wrong. We're gonna change our mind. I think it also illustrates the degree to which, like, GAO is empowered to make these kinds of determinations, is empowered to say this was illegal. And that's sort of happening on one side. It's also still true that everything we said before about the idea that sort of GAO-related processes and litigation can't possibly be the only way for these things to get adjudicated. So I think both of those things can be true, and I think it's important to say that. And then it's pretty clear to me that we are on a collision course between GAO and the White House and OMB over a lot of these things. And as I will remind listeners, because I remind everyone I talk to about this, the current Comptroller General's appointment expires at the end of the calendar year. And so we may well be headed for a nasty fight around who the next Comptroller General is and what are the powers of GAO. All right, Scott, you did a really lovely job of walking us through kind of where we are in the foreign assistance litigation. Talk a little bit about where that's going next.
So we are going to see action in that litigation on another front, separate and apart from these arguments about impoundments that the government put forward as part of a motion to dismiss. They're, again, now going to have to refile as two motions to dismiss or some other shorter brief. This past week, the plaintiffs in this case filed a motion to try and enforce the preliminary injunction to basically compel the government to finally bring forward the plan regarding how it's going to spend these funds it says that it is putting forward. Notably, again, this is something that they've started saying since March, since the preliminary injunction was issued. The preliminary injunction has been appealed to the D.C. Circuit. We're supposed to hear argument on that in early July. But notably, the government actually hasn't tried to stay the preliminary injunction on this particular issue so far. I suspect that is because they have been consistently kicking down the road saying, we're going to come up with a plan. We're going to come up with a plan. They haven't done it yet. Well, now the plaintiffs are saying you need to make them come up with a plan and produce it, Judge, or they're not going to be able to disperse these funds at all to satisfy their obligations under the Appropriations Clause to actually spend the money the way Congress intended. The government's required to file a response brief early next week, and then we're probably going to see litigation on this relatively quickly because there's a sense here on the part of the plaintiffs that they are trying to run out on the clock, and they don't want to get too close to cut off of some of these funds, to the extent they survive rescission, I should say, to the extent that it pushes them too close logistically to the end of when you really have this impoundments crisis at the end of these appropriated funds. Again, the plaintiffs haven't yet in this filing made the argument saying we're the only way the government can meet its obligations because it's failed to find any alternatives. But this is the step before that argument. I suspect we're going to see that argument, what they put forward, certainly in hearings pretty early in this proceeding, if not in briefings. I think we may see it come back because that is the surest way that these plaintiffs are going to get their funding. I don't know if this court will buy into that. I don't know if higher courts will buy into it, but it's indicative of the fundamental problem here, which is that how do you force the executive branch to spend money it has to spend, but that it does have some degree of discretion over deciding who do they give it to, under what specific terms and things like that. And that's what the courts are really wrestling with across a whole spectrum of cases here is how do you micromanage the executive branch without intruding too far on what they're doing, but ensuring they actually abide by what Congress wants them to do, and that's their duty to enforce. It's not going to be an easy set of questions. It's going to be a tricky one for Judge Ali to wrestle with, but that's coming down the pike and might come down the pike sooner than the resolution of this broader set of issues we have. So that might be the next front we see this litigation get fought out on.
Yeah, I think this is a really important point, which is just the idea to which the administration's ability to run out the clock on Congress in any number of contexts. That like asymmetry between the two branches is hugely consequential. This is obviously not the only context in which we see it. You know, we spent much of the first Trump administration, particularly the last 2 years of the Trump administration, talking about how the administration ran out the clock on subpoenas from congressional committees, but it's coming back here too. And it's, I think, a sometimes underappreciated dynamic in the interplay between the two branches.
Yeah, absolutely. Speaking of running out the clock, we have run out the clock on this conversation, Molly, but always a thrill to be able to have a dialogue with you over these exciting and deeply wonky topics. For the listener who stuck with us through this whole hour of a deep dive into rescissions, we're thrilled to have you with us as well. But until next time, Molly, thank you for joining us here today on the Lawfare podcast.
It's great to be here, Scott.
The Lawfare podcast is produced in cooperation with the Brookings Institution. You can get an ad-free versions of this and other Lawfare podcasts by becoming a Lawfare material supporter at our website, lawfaremedia.org/support. You'll also get access to special events and other content available only to our supporters. Please rate and review us wherever you get your podcasts. And look out for other podcasts, including Rational Security, Allies, The Aftermath, and Escalation, our latest Lawfare Presents podcast series about the war in Ukraine. In addition, check out our written work at lawfaremedia.org. The podcast is edited by Jen Patchett. Our theme song is from Alibi Music. As always, thank you for listening.